Okay, that's a good question. How do we get vague laws? How do we get bad laws on the books? You'd think that lawmakers would take their job seriously, that they would articulate and formulate criminal statutes that were right on the money, that didn't penalize lawful behavior, and weren't met with problems down the road because lawmakers are so intelligent that they headed off any type of issues that could result from their bad writings of statutes. The first thing you got to remember is when it comes to the government and the creation of laws, our forefathers thought it important enough to give us the rights that we would need, which would otherwise afford the protection to our citizens that the state government would not enact laws that criminalized otherwise lawful conduct. And this happens. Not because lawmakers set out to enact laws with the intention of making arrests of individuals engaged in lawful conduct, but rather due to reasons such as politically motivated enacting of laws and lobbying for laws, gateway crimes that have the effect of eroding our constitutional rights, or, as we'll talk about in a minute, alternatively granting unbridled policing power to the state government. But the way our system's set up requires us as criminal practitioners to have the foresight to try to head off the coming of disaster by way of legislation, by the way of enacting certain laws. And this happens. And we do head things off, but we don't head everything off. And putting a seatbelt on after the accident, it doesn't ease the pain. What became of the prosecutor's burden as it pertains to DUIs and the requirement that they prove beyond and to the exclusion of any and all reasonable doubt that a driver was impaired by alcohol, that their normal faculties were impaired? They don't have that burden anymore as long as they have a CMI intoxilizer result of 0.08 or above, right? What about restraining orders that used to require repeat violence? I was beat up again, so I filed for a restraining order. Maybe I'll put an end to this madness. Maybe I won't get beat up again. Now, you can file for an injunction preventing someone from sending you an email because you find them harassing. And even though an injunction by its very name means to prohibit someone from doing something or to stop them from doing something, injunctions are being granted and then used as the authority for these judges to order respondents to go on social media sites and take down any speech that they may have put up there. Forget free speech. Now you're requiring affirmative acts to be in compliance with an injunction. Temporary restraining orders, by the way, have the most teeth out of any of our Florida criminal statutes, if you ask me. They are powerful, and they can be used as weapons, unfortunately. And they're misused, and this is a tricky area when it comes to that. But another lecture. In the mid-1980s, we saw honest services fraud. The United States Congress sought to and did modify our country's federal mail and wire fraud statutes. They made it a white-collar crime to deprive someone else of their right to honest services. Now, this law was sought to give prosecutors, United States prosecutors, a tool in fighting public corruption. But when it was being put into law, lawmakers also wanted it to apply to the average Joe because they felt that the average Joe should be protected from a situation like this. From a situation where, let's say, a lawyer is hired to represent their interest, and this lawyer goes to court, let's say on a bond hearing, and didn't read every single word of the bond motion. Now, even though even a first year, even a 1 month out of school lawyer knows everything that can be alleged in a bond motion, The fact that every word wasn't read is a denial of one's right to enjoy, yep, you guessed it, honest services. That's legal conduct on the part of the lawyer. And it's prohibited from being pursued as a law by the state government. But until it's declared vague, the state can proceed with criminal charges on something on the books. So this gives the state government some real power. Gives them the right to police, to criminalize lawful conduct if something can be passed and made into law, and then puts the obligation on the defendant to petition the higher court and convince the higher court that the state government enacted a law that was unconstitutional and criminalized legal conduct. That's not an easy road. And that's not a situation that anybody wants to be in. So people under these regimes live in fear, where legal conduct is criminalized. Our system is set up to be remedial retroactively.